done. Almost all of them are interrelated. And if you are an SSN, SSN is a very popular name to know everybody. I don't know whether we have a trademark. So SSN has to be a trademark. Otherwise, somebody else can say SSN travels. Somebody may think that it's as good as SSN. The service of bus will be as good as service of SSN. So that's a misuse of your goodwill. So a lot of case studies are there. If you are interested, you can go through that. You look at litigations in IPR. Plenty of things will come, and that'll be a very interesting thing to study. Therefore, now let's go into, now we understood different type of IPRs. We have seen as a technology person, we can look at only two things: patent, which is a utility patent, or a design patent. These are two things we wanted to do. Now we look at whether our product is patentable or not. How do you see that? There are three conditions mentioned in Indian government. They say your product must have a novelty. There should have a non-obviousness, or an inventive step must be there. And there should be a utility value. Just briefly tell about all these things. Each country has got its own restrictions of what can be patented, what cannot be patented. I am talking only with respect to India. Novelty means something which is not known to anyone else. The usual example we give is about the mixie. In olden days, we used to have an ammi, where we are grinding stone moving forward and backward. A normal mechanical engineer would have automated it by putting a motor and some arms to the same ammi so that it moves faster. That's what I would have done normally. But that is the obvious extension, right? It's an obvious extension. But somebody found out that a rotating blade can also produce the same kind of paste which I'm getting in my ammi. So that's a non-obvious thing. No, I'm not aware that such thing can be produced by such an effect. So that is an example of novelty. Something which is new, which strikes you and you are not aware of it, that's not obvious. There should be a novel method. In order to verify whether it is novel or not, people use a term called prior art. What was there earlier? That's called prior art. It should not be there in prior art. This is a technical term used there. Prior art means, in this case, ammi is a prior art. Using two stones, one reciprocating over the other is a prior art. But now, what I am doing is not at all related to the prior art, but it produces the same effect by a different method. Therefore, using a mixie against ammi is a novelty. Now, one example, a popular example given is this Velcro. The plant shown here is something which triggered the inventor to develop a Velcro. So that's how a new thing came up. So nature has solved a lot of problems. And if you observe nature, bio-inspired designs, a lot of things are there. You can think about it. Plenty of things come from nature. And from there also you can pick up a lot of new products. So this is an example of novelty, not available earlier. And this is also another example of novelty. You see that, look, left side, there is a scissors kind of thing with a small scissors and a small rotating screw. If you rotate this, there will be a toothed wheel which will cut the lid here. We have a scissors kind of thing with a rotatable sharp saw, which is rotatable by this handle. We rotate this handle, this toothed wheel will cut the. This is how we were opening cans in olden days. Today, we have a simple method, an aluminum pull can. You just pull the trigger, it opens, right? So this, the fellow who invented this, Ermal Fraze, at 1961, licensed it to everybody. So every time you open a can like this, Ermal Fraze is getting some money. That is the power of a good design. You don't have to manufacture at all. You leave it to anybody to use it, but you give me money for using it. That's called licensing. So this is a very popular product which has got a heavy money by licensing. And what is non-obviousness? It should not be known to the people in that. It should not be obvious at all. So it should be, again, it's another clause of novelty. Like it should be novel. It also should not be known to people who are skilled in that place. They also should not be able to develop it. That is called as non-obviousness. And also it has another clause, it should not be known to people earlier. For example, if you publish a paper in January and go for patenting in February, when the search is done, as of February, your paper is already published. It is obvious. Then you don't qualify for getting a patent. That is the cause of obviousness. It should not be known to the public before you come to the patent office. That's called as obviousness. Non-obviousness means it should not be known. That's all. So I'll give some examples. In 1995, no, you have a patent on use of turmeric in wound healing. It was offered as a patent in 1995. They already granted. Then Dr. Mashelkar, the popular CSIR chief, he did some work, and you have to just prove that it is obvious, isn't it? How to prove it is obvious? You must show some printed document available before 1995 that we know the use of turmeric. But unfortunately, there is no such document, right? We everywhere, even in a story, you would have written the fellow fell down, there was a wound, the mother applied turmeric. Or a story, they would have written it. Even that is taken as evidence. If that book was published before 1995, it is evidence. So Mashelkar did a lot of good work, developed from Siddha medicine, from Unani, all the available medical literature. They picked up this information, proved beyond doubt that the use of turmeric for wound healing was already known to India. We don't have a patent, but it's already known to India. Therefore, you cannot give a patent to that. Like that, it was argued, and the use of turmeric, the patent was cancelled. Similarly, there was another patent in 1996. They said fungicidal use of neem oil. All of us know neem oil is very good in it. For our own cases, even when there is some disease, we keep the neem leaves as a symbol at the front door. It is very so popular here, but you have to prove it with a document. So there again, another set of people worked on it, and they cancelled the patent office, the patent itself. Later, Mashelkar didn't stop there. He did a very interesting exercise. He said, India has got a lot of good practices in medicine. There are people who know at home, elderly people give we call it as Pati Vaidyam. Then there are people who talk about Siddha, Unani, this, that, Ayurveda. Plenty of medicines are available. And literature also is abound with a lot of such information. Ramayana is there. Mahabharata is there. Everywhere they are talked about plenty of materials for medical usage. What he did is he brought a big project, the best known project in CSIR, where they brought all the people who can talk about literature. They came and said, this is what is mentioned about medicine in my place. Refer that literature, refer the page, and refer the poem also. Then you will have people who can translate this into English. Another set of people who are botanists and biologists will talk about how to give the name. For example, somebody says, I will use jasmine for this purpose. So the jasmine, they'll put a botanical name for it. That poem will be converted into English. Like this, a massive exercise was done, and they developed what is called as a traditional knowledge digital library. This is the most popular product website. I don't know how we all know or not know. It's worth talking about it someday. Please go back and visit this page, TKDL, Traditional Knowledge Digital Library. There you can find out a lot of information. For example, if I type asthma, immediately it will throw up what are the medicines, medications available for asthma, which literature has talked about it, what is the page reference number. Like you're citing your reference for a journal publication, they have provided excellent reference for all medical practices in India. Excellent work, please go through it. Today what has happened is, they have created the traditional knowledge digital library, put all the documents into a digital form and handed over to the world over all patent offices. That is why India is very, very strong in medication. Nobody can enter India with a medical patent. All over the world also, if somebody puts a medical patent, they will first scan through TKDL. Look at whether it is already existing in India or not. Only if it is not existing in India, they can get a patent. They're very interesting case studies. Of course, we'll talk about it if there is a relevance about it. So please visit TKDL. It gives you a lot of interesting things. Just for your information, a lot of things are there in the patent format, and we are very strong in the patent field. India is very strong in the patent field. Then what is utility value? You must have a utility value. You cannot say, by doing this, I can spoil this. It doesn't work. You have to show some utility. Already something is happening. I have to do better than that. Or there is a pain. I should solve the pain. Unless there is a utility value, you cannot patent it. Therefore, in publication, it's easy. I can do a research and I can say that this has no effect on the performance. You can publish it. Whereas there's no meaning in publishing such a thing in a patent. Patent will not accept it all. They'll tell you what is the use. If it is not going to be useful, why the hell you are patenting? So 50% is dropped. So unless it is useful, you cannot patent. So there are three things you have to check. Is my idea novel? Is it not obvious, not known to people in the art? And does it have a utility value? If you apply these three filters, you can develop the idea which is patentable. I got some examples. Maybe we'll share it in the next sessions. So some example of what is utility. This is a very old news item, 2010. So this patent, these slides I am holding for the past 11 years. So this is a case of SRM University. He did something where the storage became 60 times more data. So that is utility. So this kind of breakthrough utility you have to bring in order to get a strong patent. So now let's come back to our issue. What's our issue? Our issue is we keep on doing what we want to do and suddenly we want to get a patent. This is the problem. We want to think of patenting after the research is over, right? That's what we're doing in faculty. This is not the right approach. Actually, we should think of patentability well before we start the work. We'll show you some examples maybe in the later sessions where if you start with an idea and then go for a patent search, how the idea gets generated and modified into a useful product. We'll talk about it maybe in future sessions. So this is our major problem. Please understand that. We are completing the research and even sometimes publishing it. Afterwards, we want to get a patent. So this is a major problem. So how to do a patent search? Just like a literature search, we have to do a patent search. The popular technique is called patent mapping. What we do is we search the patents for a given topic, then group them like a postmaster classifies the letters. No, we try to put them into different one. Then we look at in each case what is the disadvantage, then try to work from there. We find out the gap, just like literature. But the problem is you have to do the search on the patent literature, not on the published literature. Look at the patent literature, not in the journals. This is an example. Suppose I want to do something on automobiles. I take automobile as a search word, look at all products I've got, then I try to classify them. There are people who have worked on engines, there are people who have worked on a suspension, like that I can classify. In engine, I see that everybody is working towards electric engine. In suspension, maybe people are working on air-based suspension. Like this, I'll get a bird's eye view of what is happening in that area. Then I can decide whether I should work on material or should I work on engine, etc., etc. So this gives a rough idea about what is happening in the broad area which you have chosen. In that area, what are the sub areas people are producing products? What are the levels to which they have reached? Then you can go ahead deciding your path. You can move, for example, all people are moving in electric. But I read a recent article where Ford is already having an electric car, but the feedback from a customer is the electric car is so silent, I don't feel like driving a car at all. I would love to have the engine sound. So this is the feedback. Now they are working on generating the engine sound in an electric car by interaction of air with the front grille, right? So they're planning the front grille in such a way that when air passes through it, you'll get a silent hum like a engine noise. So this is a very interesting one. I will not get to know unless I see this product, right? If I see a patent, supposing this product is coming out in, let's say 2021, they are introducing this kind of a grill. By 2019 itself, they would have applied for a patent for that. It will not get published in your journal. Your Taylor and Francis, Clarivate, nothing. Impact factor 25, nothing. These fellows will never come to that side at all. They would have patented only. So supposing I had observed the patents, in 2019, I would have known that this fellow is doing something towards creating engine noise by using the interaction of air with grill. Then in 2019 itself, I would have planned